Hi, Jim Sobach. Today, I want to talk about what constitutes a willful violation of the automatic stay. And there are two concepts here. You have a violation of the automatic stay, and you have a willful violation of the automatic stay. So a violation of the automatic stay would be if the creditor had no knowledge of the bankruptcy, took some act that violates the stay. Is that a violation of the stay? Yes, it is. Are there damages and sanctions appropriate for that? No. Why? Because the creditor had no notice. A willful violation is where the creditor knows about the bankruptcy and takes some action. So Section 362 has two parts to it in terms of defining what are stay violations. 362A tells you what does constitute an automatic stay. In other words, what can the creditor cannot do. 362B, which we'll talk about in another video, is what the creditor can do. Those are exceptions to the automatic stay. But let's talk about 362A. First, the commencement or continuation of any process for a pre-petition debt. Usually that means a lawsuit. So obviously starting a lawsuit with knowledge of the bankruptcy, which you don't see a lot of, but what you do see is lawsuits that were started before the bankruptcy was filed. The creditor's attorney gets notice of the bankruptcy and does nothing. And that lawsuit continues. The process server goes and serves the debtor. Maybe there's a garnishment that goes on the debtor's wages, because the only one that's going to stop that conduct is creditor's counsel. The sheriff's not going to take a call from bankruptcy counsel, although they should. They're not going to stop until the one who put it in their hands says to stop. So it can be an act, but it also can be the failure to act. Exercising control over property of the estate, a foreclosure, a repossession, taking property that belongs to the debtor is a violation of the stay. Same thing here with, if it's a Chapter 13, it's constituted property of the estate that's really in the trustee's hands, it's still a violation. Any act to create or perfect a lien. Maybe you enter a judgment and the person has real property. Well, you just put a lien on property of the estate. That's prohibited. Any act to create or enforce property of the debtor to the extent that such lien secures a claim before the commencement of the case. Same thing, creating liens against property of the estate. Now there's an exception that we'll talk about under 362B where you're simply continuing the lien, but this is actually creating that lien. And this is kind of the more broad prohibition that you can use in every case. Anything that you would do to try to collect a debt that occurred before the bankruptcy. It can be a phone call, can be a letter, can be a bill, can be a lawsuit. This is the catch-all phrase. Set-offs, improper set-offs violate the stay. We're going to take a whole video to talk about set-offs, but if you don't do a set-off right, that's a violation of the stay. Some tax proceedings are prohibited. Other tax proceedings and other tax mechanisms are permitted. We'll talk about that more when we talk about 362B. But those are the main things that 362A prohibits creditors from doing.